Parliament passed the Habeas Corpus Act of 1679. What is habeas corpus, and to what extent, if any, is it essential to the principle of limited government? How does the writ of habeas corpus, how has the writ of habeas corpus evolved in the United States? Under what circumstances, if any, might the writ of habeas corpus place an unreasonable burden on the government? And you may begin when ready.
In 1830, Chief Justice Marshall emphasized the importance of habeas corpus in his opinion on ex parte walk-ins, writing that the great object of the writ of habeas corpus is the liberation of those who may be imprisoned without sufficient cause. Habeas corpus protects against unlawful and indefinite imprisonment, guaranteeing a fair trial so no one is held without a charge.
Habeas corpus is essential to limited government as it upholds the rule of law. Without habeas corpus, the government may incarcerate people without evidence. Therefore, legal procedures are not equally applied to everyone in society, and the rule of law cannot exist. As William Blackstone emphasized in his commentary on Magna Carta, the rule of law is essential to limited government.
Furthermore, habeas corpus thwarts governmental abuse and restrictions to our inalienable rights. Natural rights philosopher John Locke believed governments must protect life, liberty, and property. If citizens do not have habeas corpus, the government may violate all three natural rights indefinitely by incriminating them without evidence.
In addition, if habeas corpus protections are lacking, it gives a government a gateway to restrict many other rights, such as the freedom of expression and due process. As Voltaire and Cicero argued, without the protection of free speech, limited government cannot exist, since people will be unable to advocate for their rights. Additionally, founder John Adams argued that due process is necessary to protect individual liberties and prevent governmental abuses.
Over the course of the United States' history, habeas corpus has evolved in numerous ways. The notion of habeas corpus was first incorporated into colonial charters as an extension of rights granted under the Habeas Corpus Act of 1679. When making the Constitution, the Judiciary Act of 1789 gave authority to federal courts to grant habeas relief to federal prisoners.
During Reconstruction, habeas corpus powers expanded. The Habeas Corpus Act of 1867 made the writ available to state prisoners restrained of his or her liberty in violation of the Constitution, specifically aiding Black citizens who were unlawfully imprisoned at the state level. For the next 100 years, there were no major changes to habeas powers, but in the 1960s, the Warren Court made strides to allow state governments to directly grant habeas relief to state prisoners.
However, in 1996, Congress contracted the power of habeas corpus through the Anti-Terrorism and Effective Death Penalty Act, which imposed restrictions on how and when writs can be issued to inmates. And through the Military Commissions Act of 2006, habeas corpus protections were further diminished after prisoners in Guantanamo Bay were restricted from federal habeas protections. Consequently, in Boumediene v. Bush of 2008, the Supreme Court expanded the territorial reach of habeas corpus, ruling that the suspension clause guaranteed the right to habeas review. Thus, alien detainees designated as enemy combatants held outside the United States still had the constitutional right to habeas corpus.
The writ of habeas corpus never places an unreasonable burden on the government, even during times of crisis. John Locke argues that people always have an inalienable right to life and liberty. If people are indefinitely imprisoned, they lose access to both of these rights.
Additionally, in the status quo, the United States can suspend habeas corpus under times of rebellion or invasion via the suspension clause. However, because there is no set definition for what a rebellion or invasion on public safety entails, this leaves room for public officials to deem any act a rebellion or invasion. Such a case occurred with Executive Order 9066, where innocent Japanese Americans were sent to internment camps and had their habeas corpus rights suspended. Thank you.
All right, nicely done. You referenced in your essay more recent court rulings around the writ of habeas corpus as it relates to any enemy combatants. Can you just elaborate a little bit or give your views on whether you agree with court rulings to this point and around enemy combatants? How does that just kind of speak a little bit further on that? Do you agree with the current status in that regard?
Absolutely. So following the 9/11 attacks, in 2001 and the War on Terror, many people who were deemed as enemy combatants to the United States were placed in prison at Guantanamo Bay and were restricted of their habeas corpus rights. And over the course of like 2004 to 2008, there were several court cases that related to this. For example, we have Hamdi versus Rumsfeld, in which we discussed whether or not habeas corpus provisions were extended to U.S. citizens who were deemed as enemy combatants. And the court ruled that yes, in fact, they did have habeas corpus protections. Additionally, we have Hamdan v. Rumsfeld, in which we deal with whether or not the driver of Osama bin Laden was allowed to be imprisoned and tried using military commissions, which was ruled against the favor of allowing military commissions from existing. And recently, we have Boumediene v. Bush in 2008, which ruled that the enemy combatants held outside the United States still had a constitutional right to habeas corpus in accordance with the Geneva Conventions, and as well as it may deem the Military Commissions Act as unconstitutional. And I believe that this was the correct action that we needed to take.
Thank you.
Moreover, it is important to note.
Go ahead. I'm sorry.
Okay. Moreover, it is important to note that these cases and these rulings do not just have roots in modern history, but as well as we can go back to the Roman Republic and see that these same principles were enacted. For instance, in 509 BC, a Roman consul essentially created the law known as provocatio, which is often known as the precursor to habeas corpus rights and due process rights. And so we can see that in a law called Lex Porcio I, essentially all people within 1,000 steps of the Roman Republic were granted provocatio rights. And this is very reminiscent of Boumediene v. Bush, 2008.
Yeah, but a difference between the Roman Republic's version of habeas corpus and Boumediene v. Bush today is that Roman Republic's writ of habeas corpus, or something that allows them to get freedoms and their liberties back, only existed to Roman citizens. And this is different than the precedent set today by Boumediene v. Bush, which expanded the territorial reach of habeas corpus to even enemy combatants, which is amazing, and I agree with it today.
Thank you all.
Okay, so let me go back to something you said in your prepared response. I think you're dead on accurate in almost everything you said there. That the detention of someone would be unlawful and unlimited. It would then result in a fair trial. How is it that just getting your day in court is going to give you any guarantee of a fair trial?
Although there's, go ahead.
Oh, sorry, could you repeat the question?
Yeah, in your prepared response, you made the assertion that having habeas corpus will stop the unlimited incarceration and result in a fair trial. And so my challenge question to you is, how is it that just getting into court is going to get you a fair trial?
Although habeas corpus, it's not possible for habeas corpus doesn't require like a fair trial. But the most important part about habeas corpus is the fact that no one's imprisoned without evidence. So because many people, like for example, last year in 2020 during the George Floyd protests, many people were sent into prison because they were seen as because the protest, even though it was mainly peaceful, was seen as a crisis within a crisis. Now, what does this mean? These people were deprived of a fair trial whatsoever because they were unable to judge whether or not their actions that they committed were actually violent. So even though habeas corpus may not necessarily ensure a fair trial, it at least ensures that the courts can use evidence to make sure a person's actually guilty, which is better than not having any protections whatsoever.
In addition, one of the most fundamental aspects of habeas corpus is to safeguard against having a fair trial and to make sure that your liberties are still secure. So for example, if your trial was unfairly dictated and you were convicted incorrectly, habeas corpus still gives you a foundation and a way to make sure that you're not losing your liberties even after a wrongful conviction.
I would just like to agree with both of my colleagues here. Although necessarily giving somebody a day in trial may not necessitate that they get a fair ruling, essentially, I would argue that it is much better to at least give them a trial and give them the chance for our judicial system to decide whether they were wrongfully imprisoned or not. And essentially, this is because, according to William Blackstone's book, Commentary on the Law, he emphasizes that it is much better to let 10 guilty people go rather than one innocent person imprisoned. And this is because imprisoning an innocent person without giving them their day in trial means that they lose their inalienable rights to life, liberty, and property. Moreover, in Federalist Paper 84, Publius writes that without habeas corpus and without proper due process, our republic ceases to exist because we do not have access to the rest of our rights.
We brought up the internment of Japanese Americans during the Second World War. Of course, the other very famous case of an executive suspending habeas corpus is Lincoln in the run-up to the Civil War. Could you tell me a little bit about Lincoln's thinking? And in particular, I'd be interested in hearing your opinions on whether he was justified in what he did.
Personally, we believe that Lincoln was not justified in suspending habeas corpus because we believe that it was not necessary for Lincoln to suspend habeas corpus to win the war. According to Columbia University professor of history, Eric Foner, he argues that the North was destined to win the war from the beginning. They had advanced infrastructure, they had better railroads, and even after the naval blockade of the South, they had complete control of the economy of the United States at that time. So from the start, they were destined to win the war. All the suspension of habeas corpus did was make the war, expedite the process of the war and secure the border states. And he believed that even if habeas corpus was not suspended, the Union would have won regardless.
I am in strong support of my colleague Samuk's statement. I also do believe that President Lincoln's suspension of habeas corpus had very perverse effects on society. For example, many Chicago Sun-Times reporters at the time were imprisoned for a couple of years due to the fact that they were speaking ill of the Union's war efforts. And so this is a direct attack on the freedom of expression. Moreover, even after the war in Missouri and Kentucky, over 13,000 people who were suspected of helping Confederate soldiers were imprisoned as well.
In addition, the Danish philosopher Søren Kierkegaard, in his writing in The Concept of Anxiety, says that decisions have to be made looking forward in time, but they can only be understood looking back at these decisions. And looking at every major suspension of habeas corpus, including Lincoln's suspension in the Civil War, President Bush's in Guantanamo Bay, and President Roosevelt's for Japanese internment, even though these presidents thought at the time that this was the correct thing to do, now looking back at their decisions, we now know that they were unnecessary and wrong.
How's that for timing?
There.
Time. Sorry.
Very nicely done, gentlemen. And your concluding comment was right on the mark time-wise. So most impressive. You hit the question head on and the sub questions as well. I guess some elements I was most impressed with, and it was all exceptionally well done. Your ability to support arguments with citations, you just, Kierkegaard, for example, Blackstone multiple times, the ancient through antiquity and Roman antiquity, and your references there to examples of at least some of the foundations for habeas back through antiquity were exceedingly well placed. So you complemented one another nicely. You were able to jump in and add to your colleagues' comments and reflections. So it was a fun conversation, and you did it easily, and so very nicely done. We wish you well moving forward. Thanks.
Yeah, certainly echo Steve's comments. Fantastic job. Incredibly deep understanding of these concepts. I mean, you've taken us back to, and not only to the Roman Republic, but citing Roman law. That's impressive. It shows the degree of the work you've put in. I wasn't sure what you were going to do with my question, and it was a weird one, I know, on purpose. But boy, once you got rolling, you just knocked it out of the park. And that's exactly what we're talking about, right? This is a paper document that we're living with. It's a parchment barrier, as Franklin referred to the Constitution. And well, we might not get our fair trial, but boy, if we don't have a trial at all, then that's really a disaster. So this is fundamental, and you get that. And the only thing I would say is, as you continue to work on this and you continue to study and grow, is dig deeper into the Constitution and think about the 14th Amendment and articulate it. You referred to it sort of in idea. but just throw it out there and let us know how it plays a role more directly. That's all. I mean, I'm nitpicking because you guys were fantastic. So congratulations, coach and young men.
Yeah, I'd echo all of that. The first thing that I wrote down on my little notepad here was the energy, like right out of the gate. It was strong energy, and maybe I'm wrong, but it looks like you fellas are having fun doing this, and that's the whole ball game. If you're not having fun, what are we doing here? So I salute you for that. Voltaire, Blackstone, Locke, colonial charters, ancient Rome, Kierkegaard. I don't know what else we could have thrown in there. I got so many good things to say. I think that maybe one thing to think about going forward, if it's even possible to strengthen the argument you guys gave us, it would be to hold up the other side's point of view and give it like the best fair shot you can give to them before you annihilate it, which I'm confident you would annihilate. And my only regret is I didn't have more time to wrestle with you guys on Lincoln, because I think I would have had a lot of fun doing that. These are tricky questions, and you guys have your ducks in a row, and you've clearly done your research. And I would have loved to go deeper because I'm sure I would have learned some stuff. So congratulations.
Thank you so much for all the feedback.
Thank you all so much for your time.
Yeah, thanks to
Okay.
your teacher as well.